Custody and parenting time issues are going to be contentious.
Have the parties reached their own agreement this morning?
Only to attend another mediation. Mr. Malice recently acquired counsel who was unable to be here this morning, so we are going to mediate again with the assistance of his attorney.
We have a one-year marriage. Mr. Malice, there's no attorney appearance. This court will not adjourn this matter. I'm ordering you to engage. This has been scheduled for some time. The court mailed out this notice on May 31st. We're not going to play games, Mr. Malice. The court has not received the courtesy of a phone call from attorney. There's no appearance. Mr. Goldman, have you received the notice from attorney?
No, Your Honor.
Okay, this has been scheduled. These are valuable time slots, Mr. Malice. We just can't play games here. So I'm going to order you to continue mediation. Get to your attorney on the phone. I mean, he should be here. It's a one-year marriage. There's no real estate. You've got a fee waiver. Did Mr. Malice pay the fee waiver of the $255? Mr. Malice,
Your Honor, I have since lost my job. Since the last time we were here in court.
I'm asking you whether you paid it or not.
No, Your Honor, I have not. Okay,
so that needs to be addressed in the judgment. And there's personal property, custody and parenting time. So the party has been separated since January. What items of personal property are in dispute? So I'm going to, Mr. Walker, good morning. I'm going to have you meet with the parties. And Mr. Malice, if you want an attorney, you call him right now. Tell me he needs to zoom in. We're going to mediate this matter this morning.
Okay, give me a moment, please.
There are, well, I want you, I'm not going to waste Mr. Walker's time. Mr. Schedule 8:30. Mr. Walker has a very busy schedule today. Did Mr. Malice zoom out?
He went to call his attorney.
Okay. All right. He just I don't know if he calls attorney, but I mean, this is a pretty simple matter, isn't it, Mr. Goldman?
Your Honor, I think the custody and parenting time issues are going to be contentious.
Okay. What's been the practice over the last 7 months?
The children have been in Miss Malice's exclusive care, and Mr. Malice has not attempted to see them.
Well, that's right there. That gives you a pretty good idea. If he's not filed a petition for parenting time.
I agree, Your Honor. I was, I'll look forward to hearing what his attorney has to say.
All right. All right. Mr. Malice, were you able to reach your attorney?
No, my attorney is on bed rest. He just got out of surgery for a heart valve. So I don't think I'm going to be able to get him on the phone right now.
All right. Again, all right, I'm gonna have you talk with Mr. Walker. It sounds like personal property is not really an issue. Mr. Malice, where'd you go? Well, what items of personal property are in dispute? I mean, it sounds like from Mr. Goldman, it's primarily custody parenting time. The court has been informed you've not made any effort to petition the court for parenting time. So it appears pretty clear in terms of what the court's going to look at in terms of custody parenting time. What's happened in the last 7 months? What's happened since you separated? So with that, talk to Mr. Walker. Let's see if we put the proofs on the record today, and let's move forward. And you can also give the court a date when we come back in terms of when you can pay that $255 filing fee. Ms. Malice is still on public assistance. Is that correct, Mr. Goldman?
Yes, Your Honor.
All right, we're gonna have you go back into meet with Mr. Walker again. Mr. Walker, if you don't mind, talk with the parties a little bit further this morning. I'll be available all morning.
Thank you, Your Honor.
All right, thank you.
Sarah,
Yes.
will you please put the parties in separate rooms? We're going to mediate in separate rooms.
Okay.
For the record, this matter is before the court on the plaintiff's petition for to show cause directed to the defendant as to why she not be on contempt for failing to provide insurance for the minor children. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec, representing the plaintiff petitioner Danielle Snyder. Ms. Snyder is present, and defendant Father Bradley Forgax is also present. Mr. Forgax, you're in court right now. Can you remove your hat, please?
Sorry.
All right, Mr. Forgax, you've created some problems here by discontinuing insurance for your children without notifying mother.
Yes, sir.
Have you been able to reinstate insurance for the children?
I have not. I started a new job and they do not offer insurance.
Okay, why didn't you notify mother immediately upon being informed that the insurance was being canceled.
I thought when I filed the day after I left New Way, that was covered by all that.
I'm sorry, do you know what Mr. Forgak is talking about, Ms. Nemec?
I do not. In your honor, if I may, we also have an objection to the friend of the court's child support recommendation scheduled. All of this kind of comes from a hearing before referee McKee on May 28th. And if I may, at that hearing, Mr. Forgas indicated on the record to referee McKee, myself, and Ms. Snyder that the children would be covered through June 1st. He told us that he had voluntarily left his prior employer New Way because he anticipated taking a job with a new employer. He told us that subsequently he was unable to take that job with the new employer because he maintained that he had failed the health portion of the CDL licensing. We obtained through the Secretary of State records to show that that was in fact untrue. Mr. Forgas does have the medical component of the CDL and therefore, per his own statement, would have been able to take that employment that he had left New Way to obtain. Instead, Mr. Forgas is now voluntarily underemployed, making only $600 a week. He's cut his income in half. And as the court has already pointed out, he's caused the children to go without health insurance. Unfortunately, when Mr. Forgas indicated that the children would be insured through June 1st, on May 28th, the insurance had already been canceled. It was canceled on April 12th. So when we were made aware of that and Ms. Snyder attempted to add the children to her insurance through her employer, she was unable to do it because the children had already gone 30 days without insurance. And so therefore it was not a change of life circumstance that allowed her to put them on her insurance. The children are currently uninsured. And medical expenses have been incurred due to this. Just most recently, Ms. Snyder incurred a $165 expense in order to have the party's older son, John, do his physical so that he could participate in football through school.
It's the younger son, but yes, John.
Younger, I'm sorry.
Okay. Mr. Forgax, when will you secure insurance for your new position of employment?
So I took a job after.
When will you secure insurance for your new position of employment?
But they do not offer insurance at my new employer.
All right. All right. So, because dad has no insurance, Ms. Nemec, I guess your client, if she has no insurance for employment, she can put the children on state insurance. And the court's inclined to simply order Mr. Sorgas to pay for any uninsured medical expenses incurred from and after April 12th.
Well, can I say something? So it was brought up and it was brought up. I misspoke in the hearing with the referee. I meant to say May 1st and I said June 1st. I have copies of pay stubs where I was still paying insurance after the 12th. They took it out of my check after I quit. I had talked to my boss. My boss said I'll have insurance to the end of the month. That was my understanding.
Well, that's between you and your boss. You need to, if in fact you paid for something you didn't receive, you need to address that with your former employer, Mr. Forgax. But why should this court not order you to pay the uninsured medical expenses from and after April 12th?
So, all right. So here's the other thing. We talked about the federal marketplace and Medicaid in the referee courtroom.
We?
Well, me and the referee and Danielle and her lawyer.
Okay.
That's not accurate, Your Honor. There should be a transcript of that hearing in the file.
Well, he
Mr.
brought
Forgass,
up
the question is, why should you not pay uninsured medical expenses from and after April 12th?
Because if Danielle files that, they will go back to, they have today to go back all the way to April. My wife works for DHHS. We've offered in the past, and we're offering again to help her do anything she has to do to be able to obtain that.
I'm not sure what you need to do to assist her to secure insurance for the children through the state.
Well, my wife can help her with the applications and everything because she works for the state.
That's fine. That'd be the right thing to do, but the court's going to order you that you're responsible for any uninsured medical expenses 100% from and after April 12th, 2024.
Can I say
something? To the child support recommendation, Ms. Nemec, do you want that referred back to the front of the court to reevaluate child support?
Yes, Your Honor. As I stated, Mr. Forgas on the record before referee McKee was untruthful about his ability to maintain employment or obtain employment using his CDL. He claimed that he had lost his CDL due to failing a physical. We've obtained those documents through the Secretary of State, and that was in fact not true. He had medical clearance through January of 2025.
So the thing that you obtained was unsigned by the doctor, and it says on there that if not signed is not.
It was unsigned by you.
No, it's unsigned by the doctor also.
All right.
So
the court will refer the issue of child support back to the front of the court for formal investigation recommendation. Ms. Nimick, does the court need to rescind a recommended order?
I believe that I objected ahead of it entering. So that order should have never entered.
Okay, there's no objection in the court file, so that caught me off guard that you had also had an objection before the court.
I have it stamped here. It was stamped June 10th, so I'm not sure why it's not in the file.
Oh, okay, maybe. Okay, it was filed long before your show cause. Yes,
it was.
Oh, I do see it. I'm sorry. I do see it. June 10th.
Okay.
All right. The court will.
Can I add some things here? Because
the court will rescind and cancel the front of the court referee recommend order of June 4th, 2024. Refer the issue of child support back to the front of the court for a formal investigation recommendation. And order that Mr. Forgas be responsible for any uninsured medical expenses incurred on behalf of children from and after April 12th, 2024. Mr. Forgas, do you have another question?
Yes, I do. So
what's
before
your
we went to court, yes, I'm just going to read this. Still, because there were some other parts that were sent in this, and those aren't being discussed, and I feel like it has some weight here for past medical.
What's your question, Mr. Forgas, please?
So when we went to court, Danielle said that she didn't know that I didn't have insurance, and I have a list here from Family Medical Center where she
What's
took
your
Alan.
question, sir? What is your question?
I don't have one, I guess.
Okay, so you just have a statement you want to make. Okay, go ahead. I was waiting for you said you had a question. You have a statement, so go ahead and finish your statement.
So Danielle was mailed from Family Medical Center on, let me get a date, on 4/11/24 that the kids did not have insurance.
No, I never got anything in the mail. I can give you a date on when Alan's therapist told me he was out. So Alan got sent. He goes to see a therapist at his school. It's from Family Medical Center, but she goes to the school and she saw Alan and she went to run our health insurance, and she sent me a message stating that they did not have health insurance since April 12th. I'm looking for the exact date
I believe it's
so yes, you did have that on the 3rd, but I talked to Family Medical Center.
They
told me that you were mailed out because you started a sliding scale on the 3rd.
That is not true. It was May 30th. I have the text message right here. Good morning. Do you have updated insurance on Alan? It is showing it is outdated and needs to be updated. That was on May 30th. I received nothing from Family Medical Center. Nothing.
And that was 2 days after our hearing before referee McKee, where you stated affirmatively that the children were insured through June 1st.
Yeah, and I have it backdated from Family Medical Center.
Well,
so the other thing from Family Medical Center, when Danielle went there unknowingly to me and signed our son up for care there, she filled out a HIPAA, and I was put on there as financial party responsible, but I wasn't allowed to talk to them at all. I had to actually bring them my court papers showing that I had joint custody, and they said she filled out the HIPAA, not putting you on it to be able to talk to them, but putting this boy's stepfather, which is not their stepfather, and the paperwork. And then I can go through 40 doctor visits here where I was uninformed which goes against our court order for Danielle to inform me of doctor's appointments. So the doctor's appointment she just took John to the other day was supposed to be put in the court app per court orders that she tells me about doctor's appointments. When I questioned her about it, she told me to file with the court or to go file. So I have numerous doctors, every doctor's appointment and every therapy appointment, it is in our court order, is supposed to be told to me by her in the app, and she doesn't do it.
Okay, Miss Snyder, you should be informing Mr. Forgas of those appointments. And Mr. Forgas, if you want the court to take action against you, you should file a petition for order to show cause. That will conclude this matter. The court has some other 9:30 matters still waiting. So Ms. Nemec, the front of the court short this morning. Can you please prepare an order consistent with the court's ruling, please?
Yes, I will. Thank you.
So here's my thing. If she files through DHHS for
they said I make too much money.
Right,
but they do
off the record. The court doesn't have time to allow you to converse. So the two of you can maybe get on the phone and talk with each other, talk through these issues together as parents of the children. Now we'll conclude this hearing. You can both zoom out. Have a good rest of the day. And Ms. Nemec, you'll prepare an order, please.
Yes, I will. Thank you, Your Honor.
Thank you. The record this matter is before the court on the defense objects to a referee recommended order that a bench warrant issue for defense failure to appear on June 7th and having arrearages in excess of $31,000. This hearing is being conducted via Zoom. Present is Rebecca Hicks, attorney for the Monroe County front of the court. Good morning, Ms. Hicks.
Morning, Your Honor.
The defendant Shane Fulner is present, and plaintiff mother Angie Genzel is also present. Good morning. All right, Mr. Fulner, you said you didn't receive notice. So have you kept the front of the court informed of your address? You have an obligation to keep informed when you move. You need to keep the front of the court informed. So what is your current mailing address?
That's been the same address for years. I just didn't receive notification until after the court date.
How did you receive notification? Someone call you?
No, I finally got the notification in the mail days after the original court date.
Your Honor, for the record, Mr. Fulner was very proactive. He contacted the front of the court immediately upon that, and he was advised of his options, which is why he filed his objection. He has since made payments and provided documentation to the front of the court of payments that he had been making prior to that referee hearing date, which we just needed to verify rather than them going directly through the state of Michigan's Office of Child Support. It appears as this is an interstate case, they were directed directly to the state of New Jersey. So we are just waiting on confirmation from those. But he has begun making payments and gotten that straightened out so that payments will go through the state of Michigan and reflect appropriately in our system.
All right. Thank you, Ms. Hicks. Ms. Genzel, did you understand all of that?
Yes.
Do you have any questions for Ms. Hicks?
No.
Okay, the recommendation this morning is that the court enter an order rescinding and canceling that referee recommended order. So no bench warrant will issue. And this order also makes reference to an enforcement order dated July 31st, 2024.
Yes, Your Honor, with that order, I am adjourning this matter over to October 1st at 10 a.m. on my show cause docket so we can monitor that payments continue coming in and so that we can track down the verification of those previous payments that were made so they can be appropriately applied to his arrears balance on our case.
All right, thank you. Can Ms. Genzel appear by Zoom if she chooses?
Yes, she can, Your Honor. I did give them that date, and I am including my Zoom ID on the order that I prepared, so she will receive that.
All right. Right. Thank you, Ms. Hicks. Any questions, Mr. Fulner?
No.
Okay. Court applauded you for being proactive. That's critical. And Ms. Genzel, do you have any questions?
No.
All right. Thank you, Ms. Hicks. Court will enter the order rescinding and canceling the recommended order. All right. That will conclude this hearing. You can all zoom out. Have a good rest of the day.